This hearing goes off the rails almost immediately. What should have been a basic bond violation turns into a full-on credibility war over a signature, missing paperwork, court instructions, and one very important question. Did this defendant actually know what he was supposed to do? Or is he trying to rewrite history now that he's in trouble? And trust me, that question is going to drive everything. Because once somebody says, "That's not my signature," the courtroom stops being about procedure and starts becoming about who the judge believes. And here's why this gets interesting fast. The defendant is accused of failing to enroll in alcohol testing, but instead of just arguing the facts, the defense cracks open the foundation of the whole process. Was he properly informed? Did he get the paperwork? Did someone explain the conditions clearly? Or did the system hand him a mess and then blame him for getting lost in it? That's the defense angle. But the prosecution is about to answer with court staff, phone calls, and witness testimony that may completely box him in. So watch closely, because this is one of those hearings where the violation itself is almost secondary. The real drama is in the details. Who remembers what? Who signed what? Who said what on the phone? And whether the judge sees confusion or excuse making. And by the time this is over, the court is going to decide not just whether a rule was broken, but whether the defendant is being honest about how it happened. That's when these hearings stop being administrative and start getting personal.
All right, we are back on the record in case number 253768. While off the record, the court had a sidebar with counsel, showed the defendant, defense attorney, the pretrial release order that had the bond conditions on it that contained his signature. Defendant is claiming that is not his signature, so that brings us to the court requesting a contested hearing. So I'll turn it over to the prosecution team. Your first witness.
We'll call Alex Matsky.
You swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
You may have a seat.
State your name for the record.
Alex Matsky,
And what's your occupation?
Community Corrections Officer.
And you work here in Wexford County?
Yes.
Is Brian Adcox under your supervision?
Yes.
And was he arraigned on August 22nd?
Yes.
And after that arraignment, does he get a pretrial release order?
He does from the jail.
Okay. And do you know what that information contains?
Just before you move on, just for the record, it was an in-person arraignment, not from the jail.
Oh. I'm not sure how that works then for the in-person arraignments.
Do you, do you go over this pretrial release order with Mr. Adcox?
Personally,
Okay. Just give me one moment.
Sure.
After he was arraigned, did he come down to the community corrections?
he did not.
And has he came down to community corrections to sign up for testing since then?
He came to our window and enrolled in testing on September 8th.
Okay. And when was he supposed to come and enroll in testing?
August 22nd or 23rd, depending on what time he was arraigned.
I have no.
Okay, the prosecution's first move is simple and effective. Build the timeline and let the gap do the damage. The witness lays it out cleanly. Arraigned on August 22nd, supposed to enroll in testing right away, but doesn't show up until September 8th. That's not a tiny delay. That's over 2 weeks of dead space, and in bond court, dead space is dangerous. Judges hate silence where compliance should be. But here's the twist. This isn't a hearing about whether he tested dirty. It's about whether he followed instructions. Huge difference. People People at home hear he tested negative and think, well then what's the big deal? But court is looking at the rule, not the result. If your bond says enroll, the court wants to know why you didn't enroll, period. Still, the defense has a lane here. If they can show he never clearly received the instructions, that whole timeline starts looking less like defiance and more like confusion. So now the big question becomes, was this a willful violation or a paperwork disaster waiting to happen?
Further questions? Thank you.
Ms. O'Mara?
Would the defendant have any way of knowing to report to community corrections if he had not been given his pretrial paperwork?
At arraignment, I believe judge verbally tells him what his bond conditions will be.
But does he, if he didn't get that paperwork, would he know to come talk to you?
By verbal order, typically that's what happens.
Has he reported to you since then?
He came on September 8th.
And did he test on that day?
He did not.
Has he tested at all?
He tested this morning.
Did he test positive for anything?
He was negative for everything.
Thank you, Your Honor.
Ms. Lawrence?
No further questions, Your Honor.
Ms. Matzke, I have a question. You said he didn't test on the 8th. Was one offered to him?
It was not. We
Just signed him up.
And this right here is one of those sneaky details that could matter more than people realize. When the defendant finally showed up on September 8th, he wasn't even tested that day. He was just signed up. That may sound minor, but from a storytelling standpoint, it changes the texture of the case. It suggests the system itself treated his appearance as an administrative catch-up step, not some dramatic gotcha, now let's test him moment. Now, legally, let's be clear, that does not erase the violation. The prosecution only needs to prove he failed to enroll when he was supposed to. They do not need to prove he was drinking. But emotionally, for an audience, that negative test matters. It makes him look less reckless and more sloppy, less rebellious, more disorganized. And those are two very different vibes in front of a judge. So this hearing is already splitting into two narratives. One says he ignored the order, the other says he got behind and eventually corrected it. And if you've watched enough court, you know this is where opinions split hard. Does showing up late but clean help him? Or just prove he thought the rules only mattered when he felt like following them?
correct.
All right, fair enough. Does that raise any additional questions?
No, Your Honor.
No, Your Honor.
May this witness be excused?
Yes, Your Honor.
You may step down. Your next witness,
We'll call Charlie Haskins.
Ms. Haskins. Please raise your right hand. Do you solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
You may have a seat. Before we get started, I want to do a little voir dire myself. You are a clerk in my office, is that correct?
Correct.
And the fact that you are testifying in this case and the fact that I'm your boss, so to speak, does that have any impact on your testimony today?
No, sir.
All right. Ms. Lawrence?
Thank you, Your Honor. Did you speak with Mr. Adcox on August 22nd?
Yes, ma'am.
And this was after his arraignment? And tell me about that interaction.
He was given his court paperwork and we go over that pretrial release order.
Ms. Haskins, I need you to speak up.
We go over the pretrial release order along with the next date. And then I typically follow up with where community corrections is located. I did not get to that point. I failed to direct him to community corrections after that fact. I did know that in an email after. I tried to call him to let him know. He answered, and I let him know that he would have to go test or sign up for test date. And I put him on a brief hold because he wanted to go the following day, which would have been, I believe, a weekend. So I said he could not. I was going to go ask. A couple moments later, I went to go take him off hold. He was not there. Tried calling back several times with no answer or busy to where I couldn't get through.
That pretrial release order contains his bond conditions.
Correct.
Correct.
Which was come over.
And you went over that with him? And did he sign that pretrial release order?
I believe so.
Okay. And you had sent an email correct, if you recognize this?
Yes,
This is the email you're referring to. And when you called Mr. Adcox the first time, he did answer the phone, correct? And you had told him he had to come back to sign up for testing. And to your knowledge, he hung up on you.
what, I told him I was gonna put him on a brief hold, and then, yes, there was no answer.
Now the temperature rises because the prosecution brings in the court clerk, and suddenly this stops sounding like a paperwork mix-up and starts sounding like a memory test with real consequences. Her testimony is powerful because it's detailed. She says she gave him the paperwork, went over the pretrial release order, realized afterward that she forgot to direct him to community corrections, and then called him to tell him he had to come back. That is a lot more specific than, "I think I told him." Specific memory hits different in court. And then comes the killer detail. She says he answered the phone, she explained he needed to return, he asked about coming the next day, and then the call basically died when she put him on hold. That's bad for the defense. Really bad. Because once the phone call comes in, the "I never knew" argument starts looking shaky. Not dead, but shaky. And to make it even more interesting, the judge openly addresses the fact that this witness works in the judge's office. That's smart, transparent, and honestly necessary, because viewers are already thinking it. Does that make her more believable? Or does it raise the pressure on the court to be extra careful? Either way, this witness just gave the prosecution real momentum.
And you did not hear from him after that.
No,
Do you remember what date that was, that phone call?
that would have been the date of his arraignment, August 26th.
Okay. No further questions, thank you.
Ms. O'Meara?
Your Honor, may I use your pretrial release order as an exhibit?
I'll take judicial notice of it.
Do you recognize this document? Did you go over this document with Mr. Adcox?
Yes,
If I showed you a signature, would you be able to describe it? Can you describe what that signature looks like?
that would be our judge or his signature.
Ms. Haskins, I need you to speak right up.
Sorry.
Your Honor, may I ask my client a question?
Sure.
Yes. Maybe. This is my signature right there.
Could you describe the signature for me?
Considering I don't, see a signature on it, I witnessed him sign this.
You witnessed him sign this paper.
I would do that.
Just for the record, would you do your best to describe what the signature physically looks like?
Objection, Your Honor. How is this relevant?
The question is if it's his signature. I feel like how the signatures look is a rather relevant point.
Ms. Lawrence?
She said she has never seen the signature prior to this, but that she did witness him sign it. I'm not sure how her explaining what the signature looks like is relevant.
Do you plan on introducing another piece of evidence with the signature on it,
Yes,
or purported signature? So I believe the documents will speak for themselves, so
so you don't.
I don't need her to describe the signature for me.
When you, in the conversation you did have with Mr. Adcox, did you convey the information of the date that he should start testing?
I told him that all the check marks applied, and he needs to sign up for that.
But you
And I
never,
also told him
okay. weekend and community corrections wouldn't have been open.
The court will take judicial notice that August 22nd was a Friday.
Now we get to the signature fight, and this is where courtroom reality gets wonderfully messy. The defense is clearly trying to plant the idea that the signature on the pretrial release order doesn't match the defendant's actual signature, and if they can sell that, they can attack the whole premise that he knowingly accepted those bond conditions in writing. Smart move. But here's the problem. Courts are usually not impressed by casual, "that doesn't look the same to me" arguments, unless there's something more behind it. The judge is basically saying, we are not turning this hearing into a handwriting hobby club. And honestly, fair. People sign differently all the time. Fast signature, careful signature, bad pen, awkward angle, stress, signatures drift. That alone doesn't prove anything. But it also doesn't mean the defense is wasting time. If you can create just enough doubt around the document, you give the judge a reason to hesitate before calling the violation knowing and intentional. So this moment matters, even if it feels clunky, because behind all the awkward objections and phrasing, the real question is brutally simple. Is this genuine doubt or desperate smoke?
No further questions.
Lawrence? Ms. Haskin, I have just a couple of questions for you, maybe just one. The phone number that you used to call Mr. Addicks back, where would you have gotten that phone number?
I would have received that from his file and
The AS400 is what?
our computer system that has all the defendant's information,
And how does that information get inputted into the system?
I believe during arraignment.
All right, thank you. Does that raise any additional questions?
No, Your Honor.
Any additional questions?
No, Your Honor.
May this witness be excused,
Yes, Your Honor.
temporary or permanent? Thank you. You're free to go about your day. Any additional proofs, Ms. Lawrence?
No, Your Honor.
Ms. O'Mara?
Yes, I'd like to introduce the pretrial offer sheet submitted to the court as an exhibit,
Do you have,
because it has his signature
do you
on
have
it.
any foundation to lay that?
Could I void dear my client specifically on whether or not this document is accurate?
We can swear him in and you can take some testimony regarding his signature. Yes.
Your Honor, I call Mr. Adcox to stand.
Mr. Adcox, you can stay right there. That's fine. Will you please raise your right hand? Do you solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
All right, go ahead, Mr. O'Mara. I'm sorry, Ms. O'Mara.
Mr. Adcox, do you recognize this document?
Yes, it's the one I signed on. Alex,
Or
I think, isn't it? Oh. Yeah, I signed it today with you.
and would you say that this is your signature?
Yes, that is my signature.
Does the court believe I've laid a foundation for the introduction of this document?
Ms. Lawrence. Any objection to the court considering the document?
Yes. Could you explain a little more what the document is and when it was signed?
Pretrial offers sheet signed by myself, the defendant, and Ms. Lawrence. It was submitted to the court today. Simply states that the decision in the pretrial was deferred.
Did you witness him sign that?
Yes.
The court will receive it.
I would ask, or I'd ask that the court review the signatures on those two. But other than that, I have no further proofs.
Ms. Lawrence. We won't mark it as an exhibit. That's fine. Well, yeah, no, we're good. We're good. I won't mark it as an exhibit.
Can I take it back or do you?
Yeah, I'm just wondering if Ms. Lawrence has any questions regarding the document.
Could we see the order?
You may. Here is the order. Will the parties approach, please?
Mr. Adcox, you looked at the pretrial release order, correct?
Did what?
Your attorney showed you this pretrial release order.
This is what the front looks like.
Um.
You're claiming that that is not your signature.
I mean, that's not this is my signature right here.
So are you saying that you did not sign this in front of Ms. Haskins?
I mean, that's not what. I don't remember. Did I say, I mean, when I left on the 22nd, is Miss Haskins the lady who was right there?
Yes.
I signed something when I left, but I wasn't given the paperwork. When she called me back, she did call me.
Okay,
back.
sir, only
Okay.
answer the question that was asked.
I have no further questions.
And here comes the defendant's testimony, the moment that can save a hearing or sink it. And honestly, this does not sound like a clean denial. He doesn't say, I never signed anything. He doesn't say, that document is fake. What he gives the court is something much more dangerous. Partial agreement, fuzzy memory, and uncertainty. He remembers signing something. He remembers the clerk being there. He remembers getting called back. That is not the crisp contradiction the defense needed. That is gray area. And gray area usually helps the side with the cleaner story. Now, to be fair, his actual point seems to be, yes, I signed something, but I wasn't properly given or told what I needed to do. That's a real distinction. But the problem is, judges hear uncertainty differently than jurors do. To a judge, fuzzy memory can sound less like honesty and more like retreat, like someone backing away from a stronger denial because the testimony already cornered him. This is one of those moments where the courtroom isn't just listening to words, it's reading posture, tone, confidence, and consistency. And right now, this feels less like a knockout for the defense and more like survival mode.
Right, fair enough. Ms. O'Mara, any additional questions?
I have no further questions. And no further proofs.
No further proofs. Ms. Lawrence, any additional proofs in rebuttal?
Well, Your Honor, we're wondering if we should call Ms. Haskins back to find out how many documents he signed that day.
That's entirely up to you.
Your Honor, I believe it was a permanent excusable.
She's here in the building.
I will allow her to be recalled. Ms. Haskins, you can have a seat, and I'll just remind you, you are still under oath. Ms. Lawrence?
Thank you, Your Honor. Just a couple questions. Does Mr. Adcock sign anything else other than this after his arraignment?
If he filled out a public defender form, I believe so.
Okay. And that would be what is also attached on the back of this, correct? So those two things are what he signs after his arraignment. And you watched him sign this paperwork?
PDO form, typically not because they take a minute to sign it, but the actual pretrial release order.
Okay, nothing further. Thank you.
Ms. Lawrence, can you just, I know you showed Ms. Haskin a document, but can you explain what that document was you showed her?
Yes, I apologize. This is a copy of the pretrial release order that the court and the defense both have, and it has the request for an appointment of attorney, a copy of that as well on the back.
Thank you. Ms. O'Meara, any additional, or do you have any questions for Ms. Haskin?
No, Your Honor.
All right, you may.
The closing arguments tell you exactly how each side wants this story remembered. The prosecution boils it down to a clean, hard-hitting version. He was given the paperwork, the clerk watched him sign, she called him later, he answered, she told him what to do, and he still didn't enroll until September 8th. That's it. No fluff, no drama, just a straight line from instruction to non-compliance. Judges love straight lines. The defense, meanwhile, is trying to humanize the gap. Different signature, possible misunderstanding, later compliance, negative test. Essentially, this looks sloppy, not defiant. And that's a smart frame, because if the judge sees confusion instead of willful disobedience, the defense has a shot. But the prosecution has the stronger rhythm here. Every time the defense says, maybe he didn't know, the state can answer, then why did he discuss returning on the phone? That's the problem. Once notice starts showing up in multiple forms, confusion becomes harder to sell. So now it's down to the judge's core instinct. Which version feels more natural, and which one feels manufactured?
Thank you. Any additional proofs, Ms. Lawrence?
No, Your Honor.
Argument?
Thank you, Your Honor. I think it is clear from Ms. Haskin's testimony that she did go over the pretrial release agreement with the defendant. She did watch him sign it. After looking at the pretrial statement as well as some other documents, it does look like the defendant's signature changes frequently. But I do believe her testimony that she was there, she went over it with him, she watched him sign it. We heard from Ms. Matsky that he was supposed to sign up for testing either the day of his arraignment or sometimes the day after, depending on the time. And he did not come sign up for testing until September 8th. Ms. Haskin testified that she called him. The defendant did answer the phone. She told him he had to come back for testing. He asked if he could come back the next day. When she put him on hold, he hung up the phone. Ms. Haskins also testified she tried to call him several more times and he did not answer. I think it is clear that the defendant knew he was supposed to sign up for testing and he did not. I would ask the court to find him guilty.
Ms. O'Meara?
Your Honor, we're arguing over the signatures, and the one thing I do think is clear is that the signature that Mr. Adcox provided today, which I witnessed, is not the same signature that appears on the pretrial release order. Mr. Adcox has reported to probation at this point, and he did so as soon as I communicated to him that he needed to be. And while I respect the argument that he should have known, I believe it's clear he did not know and that he did not understand, and that as soon as he did understand, he reported for testing. So I'd say that that's evidence that he did not understand or know that he needed to report for testing. Thank you, Your Honor.
Any rebuttal? Well, this was a pretty lengthy, drawn-out process for a bond violation regarding somebody needing to test. But one of the reasons the court called everybody up to the bench to go over the various signatures that it had in its file is because the various signatures that the court has in its file, in particular, the community corrections drug testing order today and the request for an appointment of an attorney, well, I have to admit, each signature appears to be different. The signatures contained in the court's file all seem to have one striking characteristic the same, and that is a line that goes down through a loop. Sometimes it's a vertical line, sometimes it's a reverse 45, but that is one consistent signature. And then when I look at the pretrial order or the pretrial statement today, while that signature is vastly different from what is contained in the file, it does have the line that goes down from a top loop down to a bottom loop, which the court believes would be the beginning of a B. I also have the testimony from Ms. Haskin today, and I will state that I give that testimony no further weight than I do anybody else testifying before this court because she's employed by me. But she testified that she had specific recollection of contacting Mr. Adcox because she forgot to inform him that he needed to go down to community corrections to test. He then questioned whether he had to come in that day or another day because she recalled it being on a weekend. And the court confirmed that the 22nd of August was a Friday, which would lend credibility to her statements. The court also specifically remembers this arraignment because Mr. Adcox, as the court was going through his record in setting bond, argued with the court that his prior 5 OWIs were not relevant to setting bond in a drunken disorderly or public intoxication case. So perhaps the reason he didn't realize he had to go down was because of his frustration. But in any event, I do remember ordering the random testing. I know that I always advise defendants that they are to, in this situation, sign up for testing. Ms. Haskins indicated that she had given him orders to do so. When she returned to the phone, he was gone and he did not answer any of her return calls. Accordingly, I find the defendant was in violation or is in violation of his bond for fail to enroll in alcohol testing between the dates of August 22nd and September 8th. That brings us to what we do with bond moving forward. Ms. Lawrence.
Thank you, Your Honor. I do understand that Mr. Adcox has now signed up for testing as of September 8th. Although I do have some concerns that he went almost 3 weeks without testing, I would just encourage Mr. Adcox to not let this happen again. Keep in contact with community corrections, and we would ask for bond to continue.
Ms. O'Mara.
I would agree that Mr. Adcox knows now that he needs to test regardless of whether or not he should have known. He did attempt to plead guilty to not showing up to test. I somewhat apologize for the drawn out nature of this. I would ask the probation or bond to be continued. Thank you.
All right, the court will continue bond as previously set. The defendant did test negative today. He did eventually sign up. But Mr. Adcox, make sure that you are following through with your bond requirements and that you're checking in daily with community corrections to see whether your number is called.
Mr.
All right.
I apologize for all this.
There's the ruling, and the judge's logic is the story. The court openly admits the signatures don't all match perfectly. In fact, the judge pretty much says, yes, these signatures are all over the place. But then the court does what judges often do in real life. Instead of looking for perfection, it looks for patterns. The judge sees one repeating characteristic in the signatures, combines that with the clerk's testimony, the phone call, and the court's own memory of the arraignment, and that's enough. Violation found. But here's the part a lot of viewers miss. The judge finds the violation and still continues bond. That is huge, because it means the court is saying, I think you messed up, but I'm not ready to throw you in jail over it. That's not a total win for either side. The prosecution gets the finding, the defense avoids the nuclear option. In courtroom terms, that's a split result. And honestly, it feels like the judge is sending a very specific message. I believe you violated, but I'm giving you one more chance to stop making this worse. That's the kind of ruling that sounds mild on paper, but feels like a warning shot in real life.
Okay, we are adjourned. Thank you.
And just like that, the courtroom switches gears into a completely different type of bond problem, a no-contact allegation. And if the last hearing was about paperwork and confusion, this one is about risk. Different energy, different stakes. Because when courts hear possible no-contact violation, they're not just thinking about technical compliance. They're thinking about safety, intimidation, escalation, and whether someone is testing the boundaries of a court order. What's interesting here is that both sides pump the brakes. The defense wants a contested hearing. The prosecutor says the issue only came up up that morning and needs more time. That's actually a good sign. It means nobody wants to rush a ruling on incomplete facts. But while the hearing gets delayed, bond doesn't just pause in a vacuum. The court still has to decide what to do right now. And those interim decisions often tell you a lot, sometimes more than the final ruling, because when a judge changes bond conditions before the full hearing, that means the allegation already has enough smoke around it to get the court's attention.
A couple of matters. One is a pretrial, and the other is an arraignment on a bond violation. I just signed the request for bond violation this morning. It is alleged in the bond violation that between the dates of August 15th, 2025 and August 24th, 2025, there was a violation of the court's no contact order. Mr. Hartel, were you aware of that violation?
I was, it was brought to my attention earlier today by the prosecutor.
Mr. Fryer, you do have the right to have a contested hearing regarding that bond violation, and at which time the prosecution would be required to present evidence to show that a violation had occurred, or you could enter a guilty plea to the violation today. Mr. Hartel, how does your client wish to proceed?
We would ask for a contested hearing, Your Honor. It's my understanding that people might be asking to set this out. We would not object to that.
So I assume there's no resolution to the underlying case as well, is that correct?
That is also correct.
Mr. Carnes?
Your Honor, I did just discover this early this morning, and I would need additional time to prepare for a hearing.
All right, the court will set this matter for a contested hearing. We'll have it before the final pretrial. How much time do you think you need, Mr. Carnes?
1 week would be sufficient.
We don't have a judge that day, do we?
Have to go to the 24th
Will Monday, well, no, I'm not here
or
Monday.
Friday the 19th.
Will Friday the 19th work?
Yes, Your Honor.
All right. Mr. Hartel, will that work for you?
I'll have to check real quick if that's all right.
Sure. I don't believe there's circuit court that day, but I could be wrong.
They're safe and sorry. Time in the day. What's wrong?
In the afternoon.
I am seeing that I have some things in the afternoon. It might be here in district 11, 2 o'clock,
It looks
2:15.
like you have a PD on Taylor Hendricks in the afternoon at 2:30.
And then they just asked for a couple other things, motions.
Yes, so if it was after that, it should be fine.
We'll set it for then. Mr. Carnes, a question I have for you. It looks like this was reported through the victim impact statement. Is that correct?
Yes, Your Honor.
When was that victim impact statement received?
August 29th, Your Honor.
Any comment regarding bond in the meantime, Mr. Hartel?
Yes, Your Honor, I would ask for bond to continue, as the court did note, as far as I'm understanding, these allegations stem from before my client's more recent history, and I don't believe there's been any allegations of him committing violations while under this court's order. So I would ask to continue bond while pending these allegations. I do believe that's appropriate. For what it does help, he has been waiting patiently, and I don't believe he's flight risk either.
Mr. Carnes?
Your Honor, I just asked the court to remind the defendant that there's a contact order, as well as a no threatening or harassing behavior order. I would ask the court to add a condition of no weapons or firearms in possession while on bond.
Am I reading the statement correctly that you're using for the basis of the violation, that as soon as he got out, he started asking where I was.
That would be part of it, as well as, it sounds like he was at the house when she wasn't there, which isn't a violation of the bond as was ordered by the court, but that at one time he was in the vicinity changing the TV channel or controlling the TV with his phone. I think that's certainly harassing and a violation of the contact order.
But it's alleged that all that happened after he was released from jail.
Yes, Your Honor.
Will counsel approach? All right, well, while the court does have concerns for a potential violation of the no contact order based on the request from the prosecutor's office, I will continue the bond as previously set with the added condition that the defendant not purchase or possess any firearms or weapons. And a reminder that no contact means no contact of any kind. We'll be back here on the 19th.
This ruling is quiet, but make no mistake, it's serious. The judge does not revoke bond, but the court clearly isn't brushing this off either. Bond continues with an added condition: no firearms, no weapons, and a direct reminder that no contact means exactly that. No contact of any kind. Translation: the court is not ready to drop the hammer, but it is absolutely tightening the leash. That's a classic middle ground judicial move. The allegation hasn't been fully proven yet, so the judge avoids overreacting, but the court also sees enough concern to add a safety condition immediately. That added weapons restriction tells you the court is looking at this through a protective lens, not just a technical one, and that matters. Because even when defendants hear bond continued as a win, judges often mean it as a warning. This kind of ruling says, you're still out, but I'm watching closely. And if the later hearing goes badly, these are the kinds of moments people look back on and realize the court was already telling them exactly how close they were getting to the edge.
Sir, you can go out to the front window where you checked in and get your next court date.
Thank you.
Thank you.
Now we move into plea deal territory. And this is where court can look calm on the surface while actually being incredibly high stakes underneath. Multiple charges, negotiated resolution, some counts dismissed, guilty pleas on the rest. That's the machine of misdemeanor court doing what it does every day. But don't let the smooth tone fool you. Once a plea starts, rights start disappearing. Trial rights, confrontation rights, the right to make the state prove its case. All of that is being traded for certainty. And this deal is a textbook example. Plead guilty to larceny under $200 and driving while license suspended first, and in return, the prosecution drops the second driving count and the trespass case. Clean trade. Predictable structure, but the consequences are still very real. Fines, court costs, attorney fees, restitution, possible jail, and convictions on the record. That's why the judge's questions matter so much here. This isn't just formality. The court has to make sure the defendant actually understands what she's agreeing to, because once these pleas go in, backing out gets a whole lot harder.
These are cases 253984 SM, 3983 OM, and 3481 ST, all in the year 25. The parents and counsel.
Joanna Carey for the people.
David O'Mara, yeah, Ms. Hall.
And we are here for 3 trials. Is there any resolution in these cases?
Yes, Your Honor. It's my understanding that my client will plead guilty to the larceny and the driving while license suspended first, and in exchange, they'll drop the DWLS second and the trespass.
So the pretrial agreement sheet says that she'll plead guilty to driving the license suspended first in 34-30-81, larceny under $200 and 25-39-84. Dismiss the driving license suspended in 34-81, and looks like the trespass in its entirety in 39-83.
Driving license suspended second.
Correct. She'll plead to the first and you'll dismiss the second. Okay. Well, Ms. Hall, have you heard what the attorneys have said the resolution in these cases are?
Yes, that they're gonna dismiss the trespassing and the driving with the license suspended second, right?
So you're going to plead guilty to driving with license suspended first. They'll dismiss the driving with license suspended second. You're also going to plead guilty to larceny less than $200, and they're also going to dismiss the trespass case.
Yes,
And is that how you wish to resolve these cases?
yes, yes,
Will you please raise your right hand as best as you can? Do you solemnly swear or affirm the testimony you give in these cases will be the truth, the whole truth, and nothing but the truth?
yes,
You put your hand down. It's my understanding in file number 253984, you'll be pleading guilty as charged to larceny less than $200. That is a misdemeanor punishable by up to 93 days in jail and or a fine of $500 or 3 times the value of the property taken. In case number 253481 ST, you'll be pleading guilty to driving the license suspended first, which was a 93-day misdemeanor and or a fine of $500. In exchange for that, they'll be dismissing the 1-year offense of driving the license suspended as a second. And then again, the trespass case is dismissed in its entirety. Do you understand those charges and the potential penalties?
yes,
Back on September 2nd and July 24th, were you on probation or parole?
no, I wasn't,
And I know at least in the larceny case, you were on bond in this, with this court on the driving with license suspended case. Is that correct?
yes,
Do you remember reading and signing the advice of rights form, talked about your rights to a trial and your rights to an attorney?
yes,
Did you understand those rights?
yes,
Most importantly, do you understand that by entering a guilty plea today, you'll be giving up those rights and you won't have a trial of any kind?
yes,
Other than the plea agreement, has anybody promised you anything in order to get you to plea today?
no, sir,
Has anybody threatened you in any way?
no, sir,
And is it your own free choice to plead?
yes,
Are counsel aware of any other promises, threats, or inducements not made part of the record?
I'm not.
No, you're right.
I will say there is a $50 restitution component in the larceny case.
That's in the larceny case.
Yes, that was on the pre-trial sheet.
Ms. O'Mara, do you agree that that's part of the plea agreement?
Yes, Your Honor.
Ms. Hall, do you understand that as part of your plea agreement, you're agreeing to repay $50 to Heather Lee as part of the larceny case?
yes,
All right. Then to the allegation that on or about September 2nd, 2025 in the city of Cadillac, Wexford County, how do you plead a larceny less than $200?
I plead guilty,
And to the allegation that on or about July 24th, 2025 in the city of Cadillac, Wexford County, how do you plead to operating a motor vehicle while your license was suspended, denied, or revoked?
I plead guilty,
In order to accept that plea, I must have you tell me what it is that makes you guilty. So we'll start with the older case first. Were you operating a motor vehicle on July 24th of this year?
yes, sir,
And that was in the city of Cadillac?
yes,
And had your license been suspended, denied, or revoked?
yes, they were,
And did you know that?
yes,
All right. Then turning to the newer file, on September 2nd of this year, were you in the city of Cadillac?
yes.
And did you steal pop cans belonging to Heather Lee?
I stole some pop cans, yes, from my residence.
And do you believe that those pop cans had a value of less than $200?
Yes, less than that, yes.
All right. Do counsel believe the defendants provided factual, well, let me ask you, and you did not have permission to take those pop cans?
I didn't have permission, no.
And it was your intent to permanently deprive Ms. Lee of those pop cans?
Well, it was my intent to take the pop cans.
And you weren't going to give them back to her?
No,
All right. Do counsel believe the defendant's provided a factual basis to accept the plea and the court rule has been complied with?
I do.
Yes, Your Honor.
As does the court. I find the pleas are knowing, voluntary, and accurate. Ms. Hall, in 253984, I find you guilty of larceny less than 200. And in 3481 ST, I find you guilty of driving.
Now sentencing starts, and this is where a case about pop cans suddenly stops sounding small. Defense counsel tries to soften the story. Maybe she thought the cans were trash. Maybe this isn't the kind of offense that usually deserves jail. Maybe fines and restitution are enough. That's a classic mitigation play. Reduce intent, reduce danger, reduce punishment. And on a vacuum, that argument might land. But the prosecution comes back with the exact thing judges hate hearing: repetition. Not one bad choice, not one isolated lapse, a pattern. And pattern changes everything. Once the prosecutor starts listing prior theft-related behavior, prior license issues, and a longer record of nuisance conduct, the tone shifts from mistake to history. That's when defendants get sentenced for more than the moment, because sentencing isn't just about what happened this time. It's about whether the court believes anything short of jail will make a difference. And when the state frames you as someone who keeps doing the same thing over and over, that is a brutal setup going into the judge's ruling.
The license suspended first. Are we able to sentence today?
Yeah.
Any allocution, Ms. O'Mara?
Yes, Your Honor. While I respect that these new charges were picked up while the defendant was already on bond, I would say that it was a genuine belief that these cans at least were trash. They obviously weren't. They do have a value. People return them. She understands that now, not to cans. As well, the driving while license suspended first. It would be a crime that ordinarily wouldn't receive jail time. And I would ask, well, the defendant, the defendant has ties to the community. I would ask for fines, costs, and restitution. I don't believe a term of probation will be helpful in this case, because I do believe she understands the things she were wrong. Thank you.
Thank you. Ms. Carey?
Thank you. I don't believe that what she understands what she did was wrong, because she keeps doing the same things over and over. Her history is long, and she continues to make a nuisance of herself. And that's what she's doing. And she was on someone else's property. The cans were outside the container. She took them. She knows they have a value. That's why she took them. Because they're returnable in our state. Frankly, can get some good money for returning cans. And she's driving. She doesn't have a license. She's got prior driving. She had a driving license suspended in 2024. She knows. She does know. She continues to do these things. She has trespass. Her past. She has attempt possession of a weapon in jail, unlawful driving away in motor vehicle. She had a driving while license suspended dismissed in 2022. She has prior larceny in 2021, another larceny in 2021, and her history goes all the way back, I think, to 2003. So I agree. I don't think probation is appropriate, but I don't think fines and costs are appropriate. So the people are going to ask for 30 days jail. Thank you.
Thank you. Ms. Hall, you have the right to address the court prior to sentencing. Is there anything you'd like me to know?
I just wanted to say that I'm sorry to the people that own the pop cans. I'm sorry to the court for my decisions and my choices. I just want everybody to know that I apologize.
So Ms. Hall, your attorney said you didn't realize, or you thought the pop cans were trash. What made you think that?
They were in a trash can container
And where was the trash can
up
container?
by the door.
So on private property?
It was on their property, yes.
All right, and you had no right to be on that property?
No.
And when you say it was by their door, describe that for me.
So you're walking up to the door, to the staircase on the porch, it's at the bottom step. There, before you get to, before you take the first step to the staircase and porch.
Is it a front porch, back porch, side
It's a
porch,
Porch.
front porch? Visible from the road?
It's pretty, it's visible, I would say.
All right. Is there anything else you'd like me to know?
I'm just gonna apologize.
Going through the defendant's history is Ms. Carey alluded to, there is quite a history here. In 99, there was a retail fraud third, 03 domestic violence, 03 an attempted receiving, concealing less than 200. In 03, an operating while visibly impaired, 06, an attempted larceny from a motor vehicle, 06, resisting obstruct, OWI, 07, an assault and battery, 21, a larceny 200 to 1,000, 21, larceny 200 to 1,000, 21, larceny less than 200, and 22, malicious destruction of personal property, 200 to 1,000, and attempted B&E with intent. In 21, larceny less than 200, 22, a UDAA, 22, a jail, possession of a weapon, 21, driving while license suspended, 24, trespass, 24, driving while license suspended. In 10, out of state, there's a simple larceny, $2,000 or less. On the local record, there's a driving while license suspended from 2000, 02, an MIP of alcohol, 02, obstruction of police, 05, larceny less than 200, and a possession of marijuana. There's also a fail to appear out of the 54A district court. By my count, that's 13 convictions somehow tied with either a property crime or a theft crime. And that includes the trespass, the UDA, the various numbers of larcenies, and then the receiving, concealing, or attempt, and the retail fraud third. I don't believe Ms. Hall is a good candidate for probation. One of the things the court must look at is whether or not she would be successful in not completing additional crimes afterwards. And with her lengthy history, the court is not convinced of that. The court is aware of the presumption that these crimes carry with it the presumption of no jail or probation. And so I'm going to start with that. In the driving while license suspended case, get the right sheet in front of me. There'll be a $75 crime victims rights fund fee, $50 state minimum fee, $150 fine, $150 court costs, $150 attorney fee, 0 days jail with 0 days credit. I've not heard anything that would leave the court to get over the presumption in that case. Now turning to the larceny case, I do believe the court has reasonable grounds to place the defendant in a period of incarceration, given the numerous 13 offenses. I also show that she currently owes the court $2,007 since 2021 with absolutely no payments. So I have no faith that she's going to pay the restitution that she's agreed to, and nor has probation been successful in the past if she has been placed on it. So as such, I find there is reasonable grounds to incarcerate the defendant. I realize that we are dealing with pop cans, but not only was this a larceny of those pop cans, this was essentially a trespass onto the property to steal those pop cans. While she may not have officially met the requirements of a trespass charge, she was on property that she had no right to be on and then committed a theft. The court has 93 days at its disposal. I believe, given the defendant's prior history, that she warrants a 60-day jail sentence. So there'll be 60 days jail with 2 days credit, $75 crime victims rights funds fee, $50 state minimum fee, $150 fine, $150 court costs, $150 attorney fees, $50 to Heather Lee. Ms. Hall, because I have sentenced you to a period of incarceration, which seems crazy for stealing a pop cans, but it's your history and your actions that put you there. You do have the right to appeal that decision. If you decided that you wanted to appeal it, you have 14 days from today's date to request the appointment of an attorney if you could not afford one to assist you. Additionally, any balance that remains unpaid for more than 56 days will have a 20% penalty assessed to it.
60 days in jail for stealing pop cans. That's the sentence. And yes, that's the kind of ruling that will absolutely light up a comment section. On the surface, it sounds wild. Even the judge basically says it sounds crazy. But then the court explains the real reason. This isn't about pop cans in isolation. This is about a long record, repeated theft-related conduct, unpaid court obligations, and a total lack of confidence that probation or restitution alone is going to work. That is how low-level cases turn into real jail time. Not because the item was priceless, but because the history is heavy. The judge even splits the difference. No jail on the suspended license case, but real incarceration on the larceny. That tells you the court is tailoring the punishment to what it sees as the more meaningful pattern. Still, this is exactly the kind of sentence that divides audiences. Some people will say, enough is enough. Repeated theft gets consequences. Others will say, this is a harsh system throwing jail time at poverty-level crime. And honestly, that tension is exactly why cases like this hit so hard online.
We are adjourned. So do I take this case up now or not?
You don't have to, they haven't appeared.
They have not appeared. All right, I'll put that one to the end then.
And now we get one more twist. A domestic violence case that's supposed to resolve as a plea to disturbing the peace instead. That is a major downgrade in legal framing, social stigma, and long-term consequences, which is exactly why judges have to be careful here. When a plea gets amended down, the court can't just shrug and say, well, both sides agreed. The judge still has to make sure the facts on the record actually fit the crime being pled to. This is where people misunderstand the courtroom all the time. A plea deal is not magic. It is not self-executing. The judge is not just a stamp. If the facts don't line up, the judge can stop the whole thing. And that's what makes this next moment so important. Because the defendant starts talking, more details come out, and suddenly the neat little plea package starts wobbling. This is exactly why experienced judges ask follow-up questions, because sometimes one extra answer changes the entire legal picture.
Court next calls the cases of the people of the state of Michigan versus Christina Marie Wood. This is just one case. This is case number 253765 SM, appearances counsel.
Nate Carnes on behalf of the people. Robert Hartel from Ms. Wood joins me at the table, Your Honor.
And we are here for a pretrial conference. Is there any resolution in this matter?
Yes, Your Honor, it's my understanding that the defendant will be entering a guilty plea to an added count of disturbing the peace, and he will dismiss the charge count of domestic violence.
Mr. Arcel?
That is accurate, Your Honor.
Ms. Wood, have you heard what the attorney said the resolution in this case is?
Yes, Your Honor.
And is that how you wish to resolve it?
Yes.
Please raise your right hand. You solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
It's my understanding that today you'll be entering a guilty plea to disturbing the peace, which is a 90-day misdemeanor and or a fine of $500. In exchange for that, the people will be dismissing the domestic violence charge, which is a 93-day misdemeanor and or a $500 fine. Is that your understanding of the plea agreement? Back on August 21st of this year, were you on probation or parole?
No, sir.
Were you on bond?
No, sir.
Do you remember reading and signing this advice of rights form, talk about your rights to an attorney and your rights to a trial?
Yes, I do.
Did you understand those rights? Most importantly, do you understand that by entering a guilty plea today, you'll be giving up those rights and you won't have a trial of any kind?
Yes, sir.
Other than the plea agreement, has anybody promised you anything?
No, sir.
Has anybody threatened you in any way? And is your own free choice to plea today?
Yes.
Are counsel aware of any other promises, threats, or inducements not made part of the record?
No, Your Honor.
No, Your Honor. Then, Ms. Woods, the allegation that on or about August 21st, 2025 in Herring Township of Wexford County, how do you plead to disturbing the peace?
I think guilty, sir.
In order to accept that plea, I must have you tell me what it is that makes you guilty. So what happened back on the 21st of August?
I got into an argument and
I can't hear you.
I'm sorry.
got into an argument and was disturbing the peace. So that's when I plead guilty.
That's when what?
So that's why I was going to plead guilty.
Did that happen in Herring Township?
Yes, it did.
And how was it that you disturbed the peace by your argument?
When I had gotten out of the car to house, I wasn't left alone by the person that I was with. So the argument, got to the car.
How did that disturb the peace? You may.
Man, how would you describe the volume of the conversation you were having with the other party? Was it higher than the average conversation level? And was this in a parking lot?
Yes, it was.
Was that parking lot like near any other buildings? Or
Yeah.
okay, so is it possible that other people could hear you yelling with the other party? All right. I do believe yelling in a public parking lot would be enough to disturb the public peace, Your Honor.
How did it come to the attention of law enforcement? Do you know, Ms. Wood?
He said he was calling the police. I had opened the door at that point, and I'm not sure if he actually called the cops, but after I got punched in the face, I guess somebody else called the cops. And then they said they saw a video of me yelling.
So were you yelling inside of the car?
No, I was yelling outside.
Okay, and what parking lot was this?
It was at Fox Motors.
Was Fox Motors open to the public that day?
I believe so.
Court will take judicial notice. August 21st was a Thursday. What time of day or night did this happen?
It was around 4 p.m.
Mr. Carpenter. Counsel believe that the defendants provided a factual basis to accept the plea and the court rules have been complied with.
Yes. Yes, Your Honor.
Ms. Wood, did I hear you say that this was after you had been punched in the face?
Yes, sir.
Counsel, I'm not going to accept that plea. Ms. Wood, that has nothing to do with anything you've done today, just based on the facts as presented to me today, I am unable to accept that plea. So we will set this matter for a final
Your
pretrial.
Honor, would it be possible for Mr. Hartel to ask me more questions?
I suppose.
If I may regroup briefly.
My apologies, Your Honor. I think we should just set it for a final pretrial conference.
All right, we will set this for a final pretrial conference. And in between time, if the council wants to try another plea, we'll certainly allow that to happen. Ms. Wood, as I stated, this has nothing to do with anything that you've done wrong. It's just how things go sometimes. You can go out to the front window where you checked in, get your next court date, and just a reminder that your bond conditions continue. Okay, thank you.
Next, one case instance,
And now we get one more twist. A domestic violence case that's supposed to resolve as a plea to disturbing the peace instead. That is a major downgrade in legal framing, social stigma, and long-term consequences, which is exactly why judges have to be careful here. When a plea gets amended down, the court can't just shrug and say, well, both sides agreed. The judge still has to make sure the facts on the record actually fit the crime being pled to. This is where people misunderstand the courtroom all the time. A plea deal is not magic. It is not self-executing. The judge is not just a stamp. If the facts don't line up, the judge can stop the whole thing. And that's what makes this next moment so important. Because the defendant starts talking, more details come out, and suddenly the neat little plea package starts wobbling. This is exactly why experienced judges ask follow-up questions, because sometimes one extra answer changes the entire legal picture.